Hi, you're listening to the Lawyer Society Legal Podcast. In this episode, which is coming after a long time, we'll be discussing about the recent judgment passed by the Supreme Court in regard to bail and cancellation of bail. The cause title of this case is Ajwar versus Wasim, which is reported in 2024 INSC 438. Which is a citation you can use on the Supreme Court website to get a PDF copy of this judgment. This particular judgment has been reported on a lot of websites like Live Law, and the title carries the words that the same court which granted the bail can also cancel the bail. But this is nothing new. It is already settled that the same court can cancel bail, but there are a few conditions here. That is, if the investigating officer is filing a petition to cancel the bail, then the same judge who granted the bail must be hearing that petition. The exception to this is if the same judge is not available, or if the grounds on which the cancellation is sought were not put forth before the judge who granted the bail before. In such cases, a different judge can also hear the bail cancellation petition. So as I said, it is a settled law that the same court which granted bail can hear a cancellation of bail petition. But what about this judgment I think must be given more attention is the fact that in paragraph 27 of this judgment, where this is observed, the Supreme Court has said that if there are serious allegations against the accused, even if he has not misused the bail granted to him, such an order can be cancelled by the same court that has granted the bail. If you look at this particular line that says, if there are serious allegations against the accused, now there can be two possibilities. One is these allegations arose after the bail was granted. Then in such a case, obviously the same court can cancel the bail because you have certain settled illustrative grounds for cancellation of bail, which even if they didn't find a place in the bail order as such, even then if those factors are proven before the court, the same court can cancel the bail. But what if these allegations were present before the bail was granted? That is, these serious allegations were missed by the court when bail was being granted. In such cases, can the same court cancel bail? Now it is essential here to understand the concept of setting aside bail. As observed by the Supreme Court in cases like Narendra K. Amin vs. State of Gujarat, which is from a 3-judges bench reported in 2008, 13 SEC 584. Subsequent cases like Ranjit Singh vs. State of Madhya Pradesh, reported in 2013, 16 SEC 797. And also a case like Neeru Yadav vs. State of Uttar Pradesh, reported in 2014, 16 SEC 508. In all these cases, it was said that a superior court can set aside a bail order made by a subordinate court if such order was made without considering material facts or crucial circumstances, or if such order was made without recording reasons. So as you can see, if a bail is being granted without considering material aspects, material facts or any crucial circumstances, in such cases it is the superior court which has to set aside the bail. But here in this particular case, in this recent Supreme Court judgment, the Supreme Court considered the fact that the High Court overlooked several factors such as the previous criminal history of these accused persons and the period they spent in custody. All these were considered, and it was said that the High Court did not consider these material facts. In such a context, it has been said that the same court can cancel bail if serious allegations are present against the accused. It is not like this observation is made in the context of serious allegations that arose after the bail is being granted. These are serious allegations that existed at the time of the bail being granted. So, if you refer to those judgments I have already talked about, Narendra K. Amin, the Ranjit Singh case or the Neeru Yadav case, it is clear that it is the superior court which has the power to set aside bail. So it is not cancelling bail, it is setting aside the bail order. So there is a difference between cancelling bail and setting aside the bail order. So a superior court has the power to set aside bail order if the material aspects or crucial circumstances are not considered. So here I think the Supreme Court in this recent case has made a mistake, I'm afraid you shouldn't be calling it a mistake, or maybe it is a misinterpretation on my part, but to my understanding, it is that these circumstances existed at the time of granting of bail, and so if they already existed, then the same court cannot cancel it. So only a superior court can set aside such a bail order. So that is my understanding. Please let me know what you think of this particular observation, and these are obviously some nuances and they need further discussion, because if at all somebody somewhere reads the line and he gets a wrong impression of what is being said, then it may lead to some misinterpretations and misapplications elsewhere. So if you know something regarding this, or if you want to contribute your thoughts to this, do comment, share this podcast if you're listening to this on Spotify, or share this video with your legal community. If you're watching this on YouTube, do subscribe to us, and if you're watching this or listening to this on Spotify, do follow our podcast channel for more of these interesting legal discussions. Thank you. Until next time.